Hello, everyone. Welcome to our analyst call. I will let everybody join in and we can get started in about a minute. Andrew, how are you? How are you today?
I'm doing well. How are you doing?
I'm doing great. There is a lot to unpack this week. We're not going to spoil the whole session, but there is a lot to discuss today. So I'm very excited to have you. It's going to be a special session when I'm going to essentially spend a lot of time with Andrew to discuss about the latest regulatory developments on what's going on in this space, and most importantly, where we're headed. We've seen a lot of ramifications in the US, and I think there is a lot of key lessons and some really good points to discuss here. So let's wait for another minute or two, and then we can get started. Let's get started. Andrew, a lot happened over the past few days, even over the past week or so. Interestingly, I think what we need to discuss here is break down by the latest developments. We've seen Kraken and Paxos with the BUSD stablecoin. So I'm going to put you on the spotlight as well so that we can be seen. And tell us, what happened? Let's start with Kraken. So Kraken offered a staking as a service product on their platform. For reference, Kraken is one of the largest crypto exchanges in the US. And tell us what happened.
Yeah, Ellie, first of all, thanks for having me. Really a pleasure to be here. I should note that any thoughts or views I have are not legal advice and are my personal views, not necessarily the views of our company. And I think your initial comment, Ellie, that a lot happened, I think it's quite an understatement. In fact, I think this, perhaps from a legal regulatory perspective, could be the most consequential week in the last 10 years, maybe, of crypto law. What happened with Kraken? Essentially the SEC entered into a settlement with Kraken where Kraken didn't really admit or deny anything, but the SEC found that Kraken had engaged in an unregistered securities offering in the US by virtue of offering their staking as a service program. And the real key there was that the SEC essentially found that staking as a service in this particular instance, and we'll talk about maybe differentiators and how to distinguish it from other staking services, but in this particular program, the SEC felt that there was enough that it was in fact a security under US federal securities laws.
I think here for the audience, we can break down what's staking and what's lending to really go back to the basics. And I think it's very important for the audience to understand that staking is a way for securing a crypto network, whether it's Ethereum or Polygon. And the way to do this compared to Bitcoin, which is very energy intensive, is to actually use crypto assets, for example, Ether, the crypto native currency of the Ethereum network, and being randomly selected to actually verify the transactions within a few seconds. And once they get selected by the algorithm randomly, they actually get the chance to settle the transactions. So staking is a way to basically put together a settlement mechanism for the crypto network, and at the same time giving a security measure, which is basically evaluated by the number of coins denominated in dollars to understand how big the network is and how much capital is allocated for the security. So for Bitcoin, the security is measured by the number of calculations called computing power on the network to secure it. But with proof of stake networks like Ethereum, it's basically based on the number of coins or crypto assets allocated to the network to essentially secure it and verify and settle the transactions. So staking is very different from lending, right, Andrew?
100%. And with the Kraken case, what is interesting is that in looking at the SEC's order and the draft complaint, the SEC really harped on the fact that Kraken essentially commingled customer funds and that they had a liquidity reserve, so they weren't staking customer funds all the time. And that was the SEC's argument. I think even with that argument, there is debate whether that is in fact a security. But to your point, Ellie, I think classic staking as a service is really very different from lending or any type of a yield product. And I think, quite frankly, what it came down to is my guess, I don't know this for a fact, but my guess is Kraken just didn't want to fight it. They could have won perhaps, but oftentimes a win is where you get out of it before going to a court.
And one of the arguments from Chairman Gary Gensler was the fact that there was a lack of transparency on where the yield came from, whether the issuance of the yield really came from new tokens or from transaction fees or even from lending. But again, we want to reiterate that staking and lending are not the same terms, are not serving the same investment case. And most importantly, staking is really serving for securing a network, not for essentially a way to earn yield by basically lending your crypto assets. But at the same time, I think it's very important to make sure that transparency is to the utmost importance when we talk about staking as a service. But what is your view on, per se, especially like on the SEC settlement and the security arguments? Do you see this as a strong argument compared to what we've seen, for example, with BlockFi, where there was a settlement as well for the lending product, which is completely different from what we've seen here with Kraken?
I think it's very different. I think there are differentiators, particularly around, first of all, staking itself, I do not think is a security. I don't think the SEC has alleged that yet. So participating and validating network transactions, as far as we know, and receiving rewards for that participation, as long as the network's decentralized, I think the general view is that's not a security. I think there are pretty strong arguments that staking as a service is not a security under US securities laws. And what would that analysis be? I think there's probably two areas you'd think about here. One is that an investment contract? And that's when you talk about the Howey analysis that we all know about, which is an investment of money in a common enterprise with a reasonable expectation of profits through the efforts of others. A classic staking of service is the service provider theoretically is not generating the rewards. In fact, the network itself is generating the rewards. The service provider is simply helping you access the technology that you could use otherwise on your own as a validator. And I think that's the argument there. Another view could be, is this a note, which under the securities laws in the US, a note, a debt type instrument? I don't know that it's that, but that's really perhaps what a lot of these yield products are viewed as, notes and likely investment contracts. And I guess going back to your original question, are there differences between the yield product cases like BlockFi and the Kraken case? I think there are really key differences. Kraken was using the customer funds to stake, whereas BlockFi was really just engaging in lending. Staking and lending, as you mentioned, are completely two different activities, and they generate different returns. So I think there are differences. The only question is, where will the SEC go next, I guess?
And what would be the landscape of staking per se going forward? Because there are two ways to stake, where essentially you can run your own validator, or you can provide your crypto assets to a service in order to stake. Do you think the future of staking is going to change drastically after these settlements?
That's a great question. I think this settlement in particular was frustrating to crypto lawyers because staking is essential to running an efficient blockchain protocol.
Right.
A lending product is great, but it's not essential to operating a network. Where does it go from here? SEC enforcement actions are not legal precedent. They're not a court decision. This is a settlement agreement. That being said, it is precedent because it shows what the SEC is willing to go after. And I think staking programs that engage in the type of activity that Kraken did could be the subject of scrutiny in the future. And so where do we go from here? I don't think staking as a service is dead, at least not in the US. I think that there are staking service providers that will fight this if they're challenged, but it's something that the Kraken case, quite frankly, has put back on the radar.
Yeah, absolutely. No, it makes a lot of sense. And I think the beauty of the blockchain technology is the transparency, as we discussed several times together, which is we know from the genesis, since the start of the blockchain, that we know how many coins were issued. We know what is the inflation rate on a yearly basis. We also know the token allocation. And I think that transparency as well is going to be very important for, I guess, these product and service providers.
Yeah, and theoretically, the big difference between lending and earning a yield that way and staking and earning your yield through rewards is that theoretically you can track network activity. You can validate that the rewards you're receiving minus the fees from the staking provider are in fact the rewards that were given. And I agree, transparency with regard to staking as a service is fundamentally different than other aspects of generating return.
Yeah, absolutely. And also, most importantly, for the investors, well aware of sustainability, when they really care about the energy consumption, staking is one of the most efficient ways to actually secure a network, most importantly, being rewarded for that, right? Compared to proof of work tokens. But again, like the debate around sustainability, especially for the more established investors, is going to be also like a very important argument when it comes to staking, because at the end of the day, staking provides a way to secure a network and participate in the whole digital economy built on top when we think about DeFi, Web3, and all the verticals coming out of all these smart contract platforms. So no, it's a great segue as well to discuss about the innovation on top of these smart contract platforms like stablecoins, right? Stablecoins are essentially like the killer feature to provide access to dollars all around the world. There are various stablecoins. There is fully collateralized stablecoins like USDC and non-collateralized stablecoins, as we've seen with Frax and also Luna, UST. We've seen Paxos and Binance and the whole ramification with that situation where Paxos decided that they're going to start minting new Binance US dollars called BUSD. So maybe walk us through here what happens and essentially give us more spotlight and insight into what's going on.
Sure, happy to. I will add one other thing to your point about sustainability and staking. If you really think about it, staking as a service actually would make processing of the network more energy efficient because you're compiling resources and making validation more efficient. So I wanted to throw that in there, Ellie, that you really think about it, that does have more of an environmental sustainable impact. So not to take us off that topic, going back to the stablecoin one, which I think was a really good segue. Yeah, this is the two actions in the US with regard to BUSD, which is issued by Paxos. Binance is also involved with that. That was among the most consequential actions regarding a stablecoin, again, that have ever happened. And why is that? Two reasons. One is what really happened here. The New York State Department of Financial Services, which is the office I used to be an enforcement attorney at before the BIT license was issued, that office issued an order to Paxos to essentially cease minting new BUSD due to AML concerns, anti-money laundering concerns that they had regarding Binance. That was the first order. The second action that's come out publicly and has been well reported on, and Paxos responded via a public statement, was that the SEC in the US issued what's called a Wells notice to Paxos regarding BUSD. A Wells notice is essentially a warning of sorts from the SEC that they would plan to bring a lawsuit for some violation of the federal securities laws. Presumably, we don't know the exact reason why they brought it or what grounds, but presumably the argument is that BUSD is a security and that it's not registered with the SEC. So there's a non-registered securities offering. To your point, a lot has happened, and I think there's probably a lot to unpack there about what that means.
Yeah, absolutely. And I think it's a good segue to the second question, which is, do you think stablecoins are essentially securities?
It depends. I think that typical collateralized stablecoins are not securities, and I feel very strongly about that. Although in this day and age, like any of us could be proven wrong when it gets to a court, and it will, I think. Depends. It may in the US get to a court. May not, but it may. Do I think collateralized stablecoins are securities? No. The reason why I don't, and that's my personal opinion, the reason I don't think they do, again, it goes back to, is it an investment contract under the Howey analysis, which I mentioned before, an investment of money in a common enterprise with a reasonable expectation of profits from the efforts of others. When you purchase a stablecoin, you do not expect profits. Nobody buys stablecoins to make money. You buy them to do other things in the crypto ecosystem. They're really an on-ramp. They're really a liquidity provider. They give you an ability to interact with the network without having to go back to your bank partner and settle your trade within 3 days or do an ACH transaction, et cetera. So investment contract, I think the analysis is pretty clear, no. The next question is, could it be what I referred to before? Is it a note, a debt instrument? I still think no. However, could it be a note in the sense that when you buy a stable coin, you're promised to be able to redeem that, so get something back for your investment, meaning get back $1. That's what stablecoin issuers do promise. This is redemption ability. I still don't think it's a note, but I don't know the SEC's exact arguments, but if I expect them to go somewhere, it's probably going to be they're going to argue it's a note. And at that point, that would be precedent setting litigation.
It's true. I think like the good way to use the analogy of what are stablecoins and how do we compare stablecoins to traditional payment services, I like to use the analogy of PayPal, where PayPal gives access to essentially like digital dollars connected to the current financial system. But here, the overall settlement layer is not Fedwire like in the US, but it's going to be the smart contract platform, which is Ethereum, where the stablecoins are issued by, let's say, issuers like Circle. And interestingly, what I like to use here is that essentially Ethereum provides a way to have access to PayPal services, but globally, as long as someone has access to an internet connection. And that's why we've seen a lot more settlement volume on stablecoins compared to the Visa network, compared to MasterCard. Interestingly, last year, Tether settled about $18 trillion in volume last year, compared to 14 trillion for the Visa network and 7 trillion for MasterCard, right? So clearly there is a killer feature here. But again, the case of whether it's a security or not is of course up for debate. But interestingly, I think, as we discussed several times, in the ETF business, there are basically inflation-linked bonds, right, which are clearly securities. But it's not really the case here for stablecoins. But it's definitely, of course, when you think about the issuer, it provides a promise for redemptions, which of course could be the case for that. But I think I like to think about with you what would happen next. What do you foresee out of this whole debacle with BUSD? Because now we know that BUSD is going to be sunset on the Binance platform. So the main stablecoins available would be Tether and USDC. Binance also mentioned that they are exploring over non-US dollar stablecoins to launch as a product. So maybe Euro stablecoins or any other fiat currency stablecoins like renminbi. So what do you foresee coming up next, Andrew?
It's a good question. If you look at the SEC, what's been reported about the SEC Wells notice, it was only focused on BUSD. It was not focused on Paxos's other stablecoin USDP, which is Pax Dollar. And perhaps there's something about BUSD that the SEC has really sunk their teeth into. I don't know. And quite frankly, there had been some reporting that was then overturned on yesterday that Circle received a Wells notice. So there's no indication Circle as of right now has received a Wells notice. In fact, their head of policy said they had not publicly yesterday evening. And the question is the US government going after BUSD to maybe get a victory early? My view would be if the SEC wanted an easy victory, they'd go after some other stablecoins that are not collateralized that are an easier case. At least publicly, they haven't announced that yet. They might, they haven't yet. And who knows why they went after BUSD. And Ellie, to your question, what does this mean going forward? What's going to happen next? I'd keep my eye on really every other stable coin. What's going to happen? I think that if the SEC goes after Circle and Coinbase for USDC, I got to think they're going to fight that pretty hard. You look at the XRP and the Ripple case, the big challenge there is when the SEC sued Ripple, arguing XRP was a security, every exchange in the US delisted XRP. That caused the price to tank. If the SEC sued Circle and Coinbase, arguing USDC was a security, would that cause delisting of USDC in the US? It could, although I got to think that Coinbase would not delist USDC because they're going to fight it and they're going to say, you know what? We don't care. We're going to take the risk and do it. And if it is delisted, it could be depegged. But you know, that's really some things that could happen. I'm sure you've got a bunch of views, Ellie, on the research side of how that could be implicated.
No, for sure. And interestingly, because all the crypto assets are not equally the same, and we have good news here for those that don't know. We actually launched the global standard classification for crypto assets last week with the largest price fees in the space called CoinGecko. So check it out on our website, it's available. And essentially what we came up with for this initiative was to basically differentiate the crypto assets by the protocols and apply sectors and industries that we know in traditional finance where crypto assets are about to be the next disruptors. So there is cloud storage, there is metaverse, there is social media, there is financial services, and there is a lot more that where we can classify crypto assets. And most importantly, the tokens themselves are not equally the same. We talk about XRP, we talk about USDC, and these are different kinds of crypto assets. And even within the stablecoin market, we have fully collateralized stablecoins and non-collateralized. And there is a key differentiator here because in the case of XRP, where we see a delisting of the token itself, it has a huge impact on the price action where we could see 30% drawdowns within a day. But for stablecoins themselves, as long as they're fully collateralized and as long as the redemptions are met, we don't see a strong depegging to $1, right? Because the whole premise of stablecoins is to basically being fully backed, but most importantly to $1,000 on the blockchain is going to be an equivalent of $1,000 on the bank account, right? And the parity needs to be met on a per second basis. So it needs to be basically backed by a $1 equivalent in the real world. So what happened with BUSD, for example, is, I think for me, is a great experiment where BUSD is going to be sunsetted. And most importantly, BUSD is not going to be available in other crypto exchanges, especially in New York. But the parity actually was not significantly damaged. And that's basically a testament to the redemptions where the investors are able to essentially redeem to US dollars and most importantly, either swap to other stable coins or just keep their current dollars. And I think for the case of USDC or Tether, if that ever happens, it will be basically the same environment as long as the redemptions are met by the issuers.
Yeah, Ellie, you mentioned New York as well. Another aspect of whether these stablecoins are a security is whether there's an alternative regulatory program that essentially is safe enough to replace the SEC registration process. And you mentioned New York State. New York State has the BitLicense, which is the virtual currency framework. It was announced and issued in 2015. So almost 8 years ago, it was the first unified crypto regulatory framework in the United States. And likely even the world in sophisticated markets. There's also the trust company structure in New York, which essentially allows trust companies to hold assets in a fiduciary type relationship. And that could be another factor. I guess to your point, I think that'll be a big sticking point when it comes to SEC litigation, which is are these alternative regulatory regimes that have existed for years and the SEC has allowed them to exist, hasn't brought a lawsuit all that other time. Why now, to your point? And I guess I would add one other thing about, I think, a point you had made, which is this decision by the US will have major implications from a national security perspective, right? Tether, people are flocking to Tether now. That is essentially not an issue and it's located in the US. Folks are going to other stable coins that are not issued by US entities. That hurts the US from a national security perspective. So it's really counterintuitive. Stablecoin issuers, at least the big ones, have the ability to engage in freeze and seize. So they can freeze transactions on chain. They can freeze assets on chain if there's a sanctions violation, terrorist implication, money laundering. Pushing liquidity overseas in the stablecoin market could have an adverse effect on US national security considerations. So it's almost like the left hand is not talking to the right hand in the US, meaning SEC is not talking to the national security authorities. And there's just not, it doesn't seem to be a unified approach.
Yeah, agree. I think like in the aftermath of what happened over the past couple of days and week, we're going to see more requests for guidance, more requests for clarity from the regulators, especially around the world where stablecoins issuers need to operate or where crypto companies need to operate. And it's a good thing that we're seeing the the revisit of the MiCA regulation in Europe and potentially implemented in 2024, because it could become the benchmark as well in other places in the world to have a unified guidance and framework for regulating this asset class. So really looking forward to that as well.
Yeah, MiCA's, the US is quite frankly falling behind MiCA. I think it's got good things and bad things, but it exists. I think most folks in crypto law just tell us what the rules are and everybody will comply. I think that's the challenge. It's predictability, it's clarity, and quite frankly, it's stability. And the EU really is pressing ahead, as are certain other jurisdictions, but it's really a great point.
Yeah, absolutely. So what do you think about the place of Tether? Because you have dashboards tracking all of the stable coins out there in the market in real time. So check out our dashboards and you're going to receive a link after this call because you're going to have the recording. And essentially on our dashboards, we've seen yesterday millions of dollars in redemptions to BUSD, from BUSD and then to USDT, which is the stablecoin of Tether. Tell us about the place of Tether, because now we're seeing that Tether is becoming a lot more dominant than it used to be, because we've seen a decline in the market share of Tether with the rise of USDC and the rise, of course, of over non-collateralized stablecoins like Frax and UST in the past. But we're seeing the rise of Tether again, almost like the phoenix rising from the dead again. And interestingly, what do you expect of a larger market share from Tether? And I think there are two markets that you need to look into when you try to look at the dominance of Tether or any of the kind of stablecoins, which is the spot market on crypto exchanges like Kraken and Binance in the order book, and then on basically any kind of like smart contract platforms like Avalanche and Solana and Ethereum. And what we see here is that Tether is like the largest player on the order book on spot exchanges. But at the same time, when we look at the blockchain itself and the data and the inflows and outflows, we're actually seeing that USDC is the most dominant stable coin in decentralized exchanges like Uniswap and SushiSwap and others. So maybe tell us more about the rise of Tether, especially for the fiat on-ramp market, which is crypto exchanges, and the more crypto-to-crypto market for what we see on the blockchain in DeFi.
Yeah, it's funny you refer to Tether as rising like a phoenix. I think that's a pretty good analogy. Tether was the elephant in the room for years. It lost liquidity or lost AUM, I should say, because investors and traders were concerned about its collateral, were concerned that it wasn't regulated by US prudential regulators, which Paxos and Circle and others are. And now with the publication of the Wells notice on BUSD, folks are going to Tether because it's not regulated by the US government. And so the issuer is not licensed. And so it's a strange situation where you have an issuer who people had legitimate concerns about. The issuer reformed reportedly a lot of its behavior, and now it's become the dominant player because it's not in some ways subject to US jurisdiction. I think there are arguments that it could be if it's accessing US. What does this mean? I think it's a shame for the US. I think it's a shame that the New York State licensing program that Circle and Paxos are subject to, it's a really comprehensive program. It is as burdensome as having a bank charter in the US. It's not as burdensome in some ways, but in other ways, it's just as strict. And so these are legitimate companies. These are companies that undergo regular examinations, that have reporting requirements, cybersecurity requirements, insurance obligations, you name it, board approval, compliance obligations. I can't speak to exactly what Bitfinex, which issues Tether, set up behind the scenes. You're totally right. It is rising, quite frankly, like a phoenix. So I'm not sure what's going to happen.
It's interesting. And I think also it would depend on the paradigm shift that we've seen from last year, especially with the debacle of FTX, where we've seen more outflows from the crypto exchanges to more non-custodial solutions, or even like institutional grade products like ETF or ETPs. It's going to be interesting to see how the market share of crypto exchanges is going to evolve compared to decentralized exchanges like Uniswap, where we actually see that some pairs like Ethereum and USDC are actually a lot more liquid than what we see now on crypto exchanges like Coinbase and Binance and even Kraken. So that paradigm shift, I think, is going to also play a huge role as well when it comes to KYC and AML and how that impacts the issuers of decentralized exchanges protocols going forward, where we're going to see more volume and market depth as well.
Yeah, I completely agree. I think the real test will be what happens with BUSD, and then what happens if the SEC decides to sue Circle or other issuers. If that has no impact on the peg, then people might just not care. They might, quite frankly, it could take 5 years for the SEC to resolve a lawsuit against Coinbase. And in that time, Coinbase will likely be able to operate, Circle will likely be able to operate. And there's no grounds to get what's called a temporary restraining order or preliminary injunction, which are court orders to stop doing activity because there's some imminent danger. They're well past that point. They can't actually bring that because these assets have been out here for years. They haven't done anything. There's no sense that this would solve an immediate injury. Yeah, I agree. It's really interesting what would happen. And I got to think there's going to be some additional announcements coming out soon.
It's possible. Anything is possible, right? Especially in these current environments. But interestingly, despite the CPI numbers from yesterday and the fact that they were actually well above the expectations, the market has reacted pretty well to the news, which may indicate that inflation to some extent has plateaued. But interestingly, the price action is quite positive over the past 24 hours.
Yeah, the market, I still think the market is pretty strong. I still think the big players in the market operationally and from a compliance perspective are doing things the right way. It's a much more mature market than what we saw in 2018 and even earlier than that. And I also would add that I think that the US situation is not like China. I know there's been a lot of comparison. China was a unified push to essentially cease any crypto activity. I don't think the US push is unified, quite frankly. I don't know that all these regulators are coordinating with each other, giving each other heads up, planning XYZ, whatever you want to call it. In fact, I think it's quite the opposite. I think the regulators in the US are actually competing against each other, which in some ways is almost more of a challenge because each regulator in the States is trying to one-up each other, and that has resulted in continued escalations. And I think just going back to a point I was making earlier, there's an announcement today by the SEC that just came out maybe minutes before this call, that the SEC is announcing something regarding what's called the custody rule, which is a rule under the US securities laws that essentially says that if you're a hedge fund and you trade assets for external clients and you're registered with the SEC, then you have to custody securities and assets with what are called qualified custodians. And what is a qualified custodian? Typically, that's a bank or other type of financial institution. We all suspect that the SEC will come out and say that state chartered trust companies, BIT license holders are not sufficient to be qualified custodians. That's the kind of concern we have right now. And I haven't checked the news. It's possible they already announced it during this call, but that's something else to look out for. I would expect that to be the subject of a lawsuit by the states. And it's unclear if that's an actual rule or if it's a notice for comment. A lot of these rules don't go into effect because they either get sued or there's a comment period, but that's something else I think that's interesting that's going to come out soon.
I think this is a great closing thoughts on the whole situation in the US and how this will impact global crypto regulation. Do we have any questions from the audience to Andrew and myself? Feel free to raise your hands. Actually, I have a question for you, Andrew. Do you think the ramifications that we see in the US is going to also impact validating nodes, right? So anyone that basically provides a staking service, but directly connected on the blockchain and not built as a financial service, or I would say money transmitter business like Kraken and Coinbase, do you think it's going to also affect the nodes as well that are connected to the network to secure and settle the transactions?
I think it could. I think it depends on whether anyone affiliated with a node operator, right? So you think of a node, let's think of everybody who could have some impact on that, on the facilitation of transactions, whether it's staking as a service, whether it's whatever you want to call it. It could be impacted if there's overcompliance. You look at the sanctions space in the US and the AML space. The US Treasury Department oversees sanctions enforcement. They've actually said they're concerned about overcompliance, which is the letter of the law says A, and you take it a step further to prohibit A, which is otherwise legal, or prohibit B, which is legal. And so I think that to me is what, if that does happen, it's really more of a culture thing that would concern me. But I think in our space, I think people view functioning of the network, it's so fundamental and the rewards are so tremendous. I think it's worth, people will be willing to take that risk in some sense. What do you think, Alan? Do you think I got that right, or what do you think?
No, I agree. And also, I think it's hard to precisely predict the future as to how it's going to happen. But again, I think as long as the validating nodes are not categorized as brokers and basically holding customers' funds and providing custodial services, then it should be fine to some extent. But again, the rules may change as well. But again, education is so important to differentiate the nodes and the miners and staking and lending, and most importantly, where the yield comes from. So education is going to be really key here. And I really can't wait to push this through, especially with our classification across the board, to make sure that people understand no crypto assets are not equally the same. They don't serve the same use case. And most importantly, there is a clear disruptive technology here, actually helping investors and law enforcement to actually understand better what's happening behind the scenes with the transparency of the blockchain.
And I would add to that, the securities laws in any country were never meant to capture the type of services that blockchain technology provides. So these US laws are almost 100 years old. And quite frankly, it just doesn't make sense that to be a node operator, you would have to register as an issuer of a security. It's just not practical. And this technology is going to survive this. The only question is, will the US evolve fast enough to allow us to continue to be a dominant player? I think this is a bump in the road, but it's certainly not the end of the road.
Absolutely. All right. Sounds good. So thank you so much, everyone, for attending our analyst call. We hope it was very insightful and educational. Most importantly, none of what we discuss is legal advice or financial advice, of course, but you're going to receive a recording of the session alongside our latest research and reports and classifications. Feel free to reach out to us directly, email, or sending us a message on LinkedIn or social media platforms like Twitter. We're very happy to help in any shape or form. And thank you so much for your time. And Andrew, most importantly, thank you so much for making the time as well.
It was an absolute pleasure. Thanks for having me.
Thank you, Andrew. Have a great day, everyone. Have a great day, Andrew. Bye-bye. Ciao.